it's really important to get those things planned in your life. So I'm pleased to welcome Joe Druce and Sangeet Tatem from Barnes Solicitors to talk all about it. Welcome.
Hello.
Hello, hi. So, why should you make a will, and when is the best time to make a will, Sangeet?
Okay, there are a plethora of reasons why people make wills. It could be to ensure the people that you really want to benefit do inherit at some point. Might also have vulnerable dependents or beneficiaries that you might want to cater for and look after. It could be just to maximize your tax allowance, make your wills effective for tax planning, inheritance tax, and so on. It could be for many, many reasons, and to even hold assets in trust. Everyone should make a will. I mean, as long as you own a property and you own any assets in your name, you should make a will. There's never a right time to make it, but if you haven't got one in place, then you should do so as soon as possible.
Absolutely. I know from my own family we've had circumstances where one partner has sort of early onset dementia, and we thought the other partner was fit and well, and suddenly he had a stroke, and everything was kind of left up in the air. And
right.
Whilst they had made some arrangements, they never sort of anticipated something like that happening to them. So it's very important. So how much does it cost to make a will, and why should you go to a solicitor to prepare one as opposed to doing your own one online?
Wills do not cost a lot to put in place. It's usually a small cost of £200 plus VAT, what we charge for a simple will.
Oh, right, that's
if your
reasonable.
wills need to include any tax planning, any trust provisions, obviously, the cost may vary, but obviously we'll speak to you and then determine what sort of wills and what sort of drafting you would need.
Right.
Our charges are also posted on the website, so you're more than free to go and have a look and see what the cost could be.
So it's all transparent sort of thing. So supposing you haven't made a will, what are the pitfalls of that, and who ends up getting the money if you don't make a will?
Well, there can be some consequences. I mean, a lot of married people think that, as long as one of them passes away, everything will just be left to their spouses.
Yeah.
That's not actually correct, in the fact that if you pass away without making a will, you'll be considered to have passed away intestate. Then the rules of intestacy come into play, and it's not always that the spouse inherits everything, depending on whether they are children, so on and so forth. So you could be chancing as to who you would like to get the monies in due course. And
well,
sometimes,
indeed.
you have family trees that come into play, and great aunts and uncles and cousins inherit as well.
And that's when the arguments start, isn't it?
Yes,
and,
they do.
Yes, and if you've got it sort of firmly fixed in a will, then that prevents all that, doesn't it? So,
that's right.
but I mean, in those cases, can a will be challenged?
Yeah, a will can be challenged. If you haven't got a will and someone passes away, there's always a 2-year period from the date of death in which a deed of variation can be put in place. And it can vary the rules of intestacy, or it can vary the provisions of the will depending on what needs to be achieved. But the difficulty in that is that the people who might inherit might not want to be giving away some of their inheritance, and therefore might not comply and not agree. And if nobody agrees to the deed being put in place, it is quite difficult to put one in place.
Absolutely. What about the question of tax? What sort of tax do you end up paying on these things?
I mean, as far as inheritance tax is the main tax in connection when someone passes away, everyone has a tax-free allowance of $325,000.
Right. And
the basic rule that applies is as long as your estate exceeds $325,000, the excess is then taxed at 40%, which is quite a high rate.
It is, yeah.
If you've made wills leaving everything to your spouse, you get the spouse's exemption. Then on the second death, you've got your spouse's allowance to claim together with yours, so it gives you a tax-free allowance of $650,000. And if you've got a main residence as a property, then they've got residential nil rate bans that are in place since 2017, which actually give you a bit more allowances as far as tax is concerned. So for today's date, if a married couple leaving everything to each other, on the second death you're looking at £900,000 tax exemptions before any inheritance tax will apply. But there are certain rules and considerations that you need to put in place in order to have that happen.
I mean, you've got to do it right. So how do you protect your assets from going to HMRC?
Well, there are quite a lot of things that you can do. You can make sure you make a will and leave it to whoever you want to leave it. You make sure you use the charities exemption, pass some of the tax over to the charities, and that will exempt your estate from certain tax repercussions. You could also just do simple, straightforward things, in regards to severances of joint tenancy and so on. So yeah, do go and speak to
You
a
need
solicitor
a
and get
solicitor.
some proper
Yeah,
advice.
yeah, that's right. What about if you have concerns about, say, a family member's mental capacity to deal with their affairs? That sometimes causes problems, doesn't it?
Usually when people have capacity, it is much easier. You can always, deal with matters, put a will in place,
Yeah.
put the power of attorneys in place to make sure that there's someone there that can deal with the property and financial affairs during their lifetime. If you feel someone's getting a bit too forgetful, or you think that they might be heading down the route of losing capacity, then as solicitors, we would ask for a doctor's letter to confirm that they've got capacity before we start drafting wills or preparing power of attorneys for them. But it might be a good idea to actually try and put something in place at that point in time rather than leaving it too late when they've lost capacity.
Yeah.
All is not lost though, because if someone loses mental capacity and they don't have a will in place or a power of attorney in place, the Court of Protection is the court that has jurisdiction in such matters.
Okay.
And you can always get a deputyship order by the persons who need to deal with the property and finances of a person who lacks capacity by going to court. Or you can have a statutory will put in place by the court in certain circumstances.
Oh, really? Okay.
Yes.
Okay, you mentioned a power of attorney there. How long does a power of attorney last, and how much does it cost to set up?
Okay. The ambit of a power of attorney is it's in its name, the lasting power of attorney. So it will last throughout your lifetime as long as you have, as long as you've had mental capacity when you made it, and it becomes obsolete on death, and
Right.
at death the will takes place. But power of attorney, most solicitors in most areas charge around £500 to £550 plus VAT to put one in place.
Right.
There is a registration fee payable to the court, which is the Office of Public Guardian, of £82 to register the power before it can be used.
Okay. Now, care home costs is a big issue these days, and concern now how you can help someone plan for this. How can you do that?
There are a few simple things that we can all do. We can mitigate care costs in the long run by making sure that we hold our properties as tenants in common rather than on a joint tenancy basis. So you sort of mitigate the amount that the local authorities can attach when someone goes into a home, because in a tenancy in common, each party would be deemed to own a certain percentage of the property, and the local authorities can only place a charge towards the amount the person owns in their property.
Right.
Whereas on a joint tenancy, you own it to the exclusion of each other, so your percentages or shares are not defined in a joint tenancy. So the simple thing would be to effect a severance. You can have a life interest trust put in place whereby the half share of the property or the share in the property is held in trust for certain beneficiaries with a right of residence or a life tenancy for your spouse and so on. And in that effect, that should the surviving spouse go into a home, you're mitigating any care provisions only towards a half share of the property.
Yeah. It's a minefield, isn't it? There's so many sort of pitfalls in this, and you really do need a solicitor's help, I think. What about when you lose someone in your family? What is the typical process to administer their estate? For example, does a solicitor have to be appointed to do this?
Not in all cases. In some cases you will have spouses which hold everything jointly, and if everything is held jointly, then obviously you don't even need a grant of probate to administer an estate.
Right.
Come in and see solicitors, because we advise clients, and in sometimes we will tell them you don't need to extract a grant and the client can go ahead and deal with matters themselves. Some clients actually tend to extract grants on their own accord, so that is a possibility if you
Okay.
are capable of doing it. Most people like to appoint solicitors because then they're sure that any tax exemptions available are all claimed, the estate is distributed in accordance with the terms of the will, and they don't have to worry about any squabbling beneficiaries or heirs that might be.
Yeah, it's the safest way, isn't it, really?
Yes.
Now, you're also a notary public, I understand. Now,
That's
I don't know even what one of those are. What does a notary public do, and why would you need a notary?
Okay. A notary public is a legally trained person that deals with documentation for use abroad. So anything that goes abroad, whether it be of a commercial nature, worldwide transactions, inheritance, provisions overseas, you will need the documents that go abroad to be signed and notarized and witnessed by a notary. A solicitor's jurisdiction in England and Wales will extend to the area in which your practicing license is issued. So I'm a solicitor of Supreme Court of England and Wales, so I can only practice as solicitor within that jurisdiction.
Okay.
So if I were to sign any paperwork and send it abroad, it might be rejected because I don't actually have the authority to represent to third parties that I'm an officer of the court, and I can actually sign this paperwork. So a notary facilitates transactions abroad
Okay.
in most cases.
Okay, lovely. Well, thank you, Sangeet. We're going to talk to Joanna Druce now. Joanna's the